All right, I think we're live. Hello, my name is David Olshan and I work for Nevada Legal Services. Today, during our live stream, I'm going to go over pandemic unemployment assistance and the interminable delays and what you can do about it. Basically, this is how to file a writ, and we're going to discuss some other issues. So if you do have questions or comments, please post them and we'll try to deal with them. Otherwise, we'll just go right ahead. Sort of. Here we go. So no new claims are being filed for PUA. The time ran out in September. Currently under federal law, you can't backdate. You can't backdate past December 6th, 2020 for existing claims. And eventually this program will die. But so many people have been waiting for hearings. So many people have been waiting for decisions. There's petitions for judicial review that will be filed in district court. So this program probably won't wind up until probably 2023. It does take usually over a year because the district court is very lax in following the rules and following the law. The law requires a priority on these cases, but of course, no judge really follows that law. So this program, these issues will be around probably, like I said, until 2023. All right, so we're going to cover some issues that we see every day. The systemic incompetence of the Employment Security Division does create these issues, and if they only knew what they were doing, many people would not have these problems, and we wouldn't have to do these live streams, and we could all go about our business. We have seen situations where PUA has been approved, but no money has been issued. We do have a situation where one client actually got a second hearing because the first hearing they got it wrong. They actually approved a PUA claim and then went back and said, we got to do this over because we didn't deny that. So you may have that issue. It's wrong, obviously, when you get approved not to get your money or for the Employment Security Division to hold a second hearing. So we see those. We also see disregard for the law and Department of Labor guidance. This issue of connection to work. You don't have to be working on March 15th, 2020 to qualify for PUA. You just need a sufficient work history. So if you have worked, done work in the applicable tax year, you're eligible for PUA if you are otherwise eligible, if you're out of work because of the pandemic, the COVID-19 public health emergency. So many people are denied who are not working on March 15th, 2020. That is wrong as a matter of law, and that is subject to reversal if an objective, reasonable court looks at it. Also, if you have committed misconduct or even committed fraud in connection with work and apply for PUA because you're not eligible for regular unemployment, you are eligible for PUA. That's a mistake that they make. They say because you committed misconduct, you're not out of work because of the COVID pandemic. That's just wrong. The Department of Labor has issued guidance in this area. Of course, the Employment Security Division disregards it. And an argument against what I'm saying could be if the state of Nevada does promulgate rules that vary from what the Department of Labor guidance is, the Employment Security Division could use those rules. However, they haven't. The Employment Security Division is pretty lax. Obviously, they have a lot to do right now, but in terms of notice and comment rulemaking, they've done very little. And on these issues, the Department of Labor guidance should govern what the Employment Security Division does, but we know that they disregard the law and don't follow the rules. Another issue that is just systemic over at the Employment Security Division is every hearing, they pretty much act like they don't believe you. They give you this bogus warning. Are you the one who filled out this application? It's totally absurd because what they're pretending to do is fight fraud. But if you're pursuing a claim, if you've been denied and file an appeal, it's rather stupid for them to ask, are you the person who filed this appeal? Obviously, you're not a fraudster. because you're spending a lot more time than most people who commit fraud are willing to do. And that sort of common sense is just lacking. They don't believe you. They challenge everything. They want tax forms. They want employer verification. They first indicated they were interested in your self-employment gross income. The Department of Labor changed that to net income, but they will accuse people of misrepresentation by putting their gross income instead of their net income. It's really unfortunate because in these situations, the whole objective of PUA, pandemic unemployment assistance, was to get this money to people as quickly as possible and allow self-certification. That sort of changed, and what the sort of Employment Security Division does now is just accuse you of committing fraud, not filing the claim under your name, saying you're filing it from out of the country. It's just wrong. This documentation requirement, yes, you have to produce documentation of employment or self-employment and your income, but the reason for being out of work, they will require that as well. It's not, if you cannot provide it, a declaration, your testimony should be enough to say that you're out of work because of the COVID pandemic. And so these are some areas where the law does sort of favor the claimant, does favor the disbursement of these benefits, but it's totally disregarded by the Employment Security Division. With regard to overpayments, they will see if you do not have enough money right now, and if you do have enough money to pay it back, they'll ask you to pay it back. That's wrong. There's 3 conditions. You're without fault, it's against equity and good conscience, or you change your position as a result of the payment of those benefits and you can't pay them back now. I mean, it's in actually the CARES Act, 15 USC 9021. You could see it right there regarding overpayments. There's 3 paragraphs, but the Employment Security Division just uses 612-385, and that's wrong. They haven't promulgated any rules regarding overpayments, and yet still stick to this old policy under state law when federal law governs PUA overpayments. So those are just some areas. If you have been victimized by the Employment Security Division, please contact us because we may be able to help. All right. To qualify for PUA, you must basically be unemployed because of the COVID-19 public health emergency. So you're not eligible. You can't be eligible for regular unemployment. You can't be allowed to telework, that is, work at home, and you don't have leave benefits or other benefits that your employer has given you, and you're out of work because of the COVID-19 pandemic. Now, you could be taking care of a family member. You could be a breadwinner now if the former breadwinner has died of COVID. Your job has shut down, or you've faced a significant diminution in business because of the COVID virus. You would be eligible for PUA. So just if you're going to pursue these cases, if you're going to try to file a writ, just make sure you're eligible, because getting a hearing, getting some type of reaction from the Employment Security Division, sometimes it's not a good idea because you're not eligible for it anyway. So just make sure you're eligible for PUA. You don't have regular unemployment benefits available. You can't telework. You don't have any other leave or sick or vacation time coming to you. And you've been out of work, idled because of the COVID-19 pandemic. So when we file writs at Nevada Legal Services, we have 3 different situations. One is when people have applied and are simply waiting. I filed one today. Someone has been waiting over a year for a PUA hearing. If this does apply to you, the federal standard is 7 weeks, and obviously a year is longer than 7 weeks. So basically, the Employment Security Division has violated that standard. Really, the Department of Labor sets a standard of 30 days. So you can tell that if you're waiting 1 year for a hearing, you can file a writ, and you probably should file a writ because the Employment Security Division is violating federal law. Sometimes you'll get a hearing, but it's 2 months or more away. So that's another situation. If they have to disperse your benefits in 7 weeks, obviously a hearing in 2 months doesn't comply with that standard. So that's another situation where you do get some reaction. You do get a hearing set, but it's off in the future, more than 2 months away. You would be able to file a writ under those circumstances. And then finally, there's a situation where your hearing has been held, but the referee, the appeals tribunal, has not issued a decision. The Board of Review has not reviewed your case. If that delay is more than 2 months, you can file a writ and get the Employment Security Division, the appeals tribunal, or the Board of Review to issue a decision, because again, the standard is 7 weeks. The 7-week standard is from the time you apply to the time your benefits are dispersed or you get a decision. So if you're waiting a year for a hearing, you get a hearing, and then it's another 2 or 3 months before a decision, that's not right. That violates the Constitution. Unfortunately, it happens every day. So if this does apply to you, you can file a writ. I will go over where you can find that writ and do it on your own. We simply don't have the resources here at Nevada Legal Services to help everyone. We'd need 10 times the amount of staff we have now. And the unfortunate sort of circumstances, we just have limited time. There's 24 hours in a day, and we just don't have the time to help everyone who's been harmed by the Employment Security Division. Finally, there's another situation that we see when people change banks. Sometimes your benefits will stop. They'll say pending when you go to your portal. If your benefits stop, we had one person in Sparks, their benefits stopped for over 2 months. We filed a writ. They can't, the excuse that the Employment Security Division gave was we need somebody with higher authority to fix the problem. Well, God is not around to fix these problems. So we filed a writ. Hopefully their benefits will begin again. It's simply a matter of changing banks, and the Employment Security Division thinks that fraud has been committed because those banks are being diverted. They're being diverted to a bank that somebody has changed. So it's a simple phone call or a conversation that could fix this problem. Unfortunately, the Employment Security Division doesn't do that. All right, so for your appeals, keep in mind almost all of this information is going to be in your online portal. So if you want to appeal, you have to click the link that's next to your notice of determination if you do want to appeal. You do have to appeal every notice that the Employment Security Division issues, and it does get burdensome, but each notice will say this notice supersedes the previous notice. And what the Employment Security Division does is, by their constant sort of notices of determination, they change the goalpost. They change the time period, or at least they think they do. They try to start the clock over by issuing a new notice. It doesn't really work that way. If you don't get your benefits, it doesn't help if they give you 20 notices over the space of a year. It's been a year since your initial application. Okay, so when you get a decision, you will hear the appeals tribunal say, we'll give you this decision in 7 to 10 days. That doesn't happen. It usually takes a couple of months. And like I said on the previous slide, you can file a writ if it takes more than 7 weeks. Also, when you do go to a hearing on your PUA appeal, the referee might not have access to all the documents. So please make sure that all of your relevant documents are there. If they're not there, they could hold that against you. And you have basically one opportunity to create a file, an appeal file. And so you want to make sure all the documents are there. If you have employer verification or tax forms that aren't in your appeal packet, make this known to the referee, the appeals tribunal, and your case you should be allowed to upload that information to the appeals tribunal and get that in the record. All right, a writ. Again, you need to be eligible for PUA. I would strongly encourage people to review that just to make sure. But when the law requires the Employment Security Division to hold a hearing, issue a decision, pay PUA, and you have no adequate remedy at law, no opportunity to file a petition for judicial review, then you can file a writ of mandamus. Generally speaking, the way this works is you get a determination from the Employment Security Division, you You have a hearing in front of the appeals tribunal. If you lose, it goes to the Board of Review. The Board of Review decides, and then within 10 days of that decision, if you're denied, you file a petition for judicial review. If this process is destroyed by no notice of the hearing, no decision, you can file a writ. You must file it in the district where you worked, where you live. Once you file that writ, and those forms are available on our website, you need to mail it to the Attorney General's office and to the Administrator of the Employment Security Division, Linda Parvin. If you get a writ issued, if there's a briefing schedule issued, and the court orders service, actual service under Rule 4, then you have to have a process server serve the forms to Linda Parvin in Carson City. Our writ of mandamus form is on our website, and the next slide will show you. The next slide will show you the link to the website. But again, we have personally, I probably filed 30 writs so far, beginning, I don't know, July of 2020. We don't have the resources to help everyone, and that's why we made the self-help form available. So please call us if you have one of the issues that I talked about. If you want help with your PUA claim or your regular unemployment claim, we do help with those issues. You can do an online intake at nevadalegalservices.org. Also, you can get that writ form at nevadalegalservices.org. Go into the form section. It's available. Oh, shoot. Anyway, it's available. Oh, there we go. It's available there, and it might help you. If we can't help you because we don't have the resources, then you're going to have to do this yourself. We have made the instructions available. Hopefully you understand them, and good luck. We do realize this is a serious problem. So far, the governor, the Nevada legislature, the court system, they have not really helped the people who are suffering here in Nevada, and we do the best we can. So if you do have some questions right now, I'll try to answer them. And Brianna, do we have questions or comments?
Let me check on YouTube really fast, but
Okay.
there appears to be nothing on YouTube.
All right, well then I'll just sign off. Good luck. And please visit our YouTube channel because we do upload information periodically to help you with unemployment benefits, landlord-tenant issues, record sealing, things like that. I'm David Olshan. Thank you for watching, and